All right, so we're going to get started. This panel is called Policy That Meets the Challenges of the Future. And we have four exciting presenters who will speak on different aspects of policy through advocacy and through the courts. My name is Paula Dinerstein. I'm the general counsel for a group called Public Employees for Environmental Responsibility, or PEER for short, and I'm also on the board of Beyond Pesticides. And I just wanted to do like a few housekeeping things before we get started here. This workshop is going to go from 3:45 to 4:45, at which time we have a hard stop. So I hope nobody gets cut off. Try to be prepared for that. That's just the way the platform works. Everybody in the audience should please mute your mics for the whole time. We will have a question and answer session. It will be after all of the four presentations, but you can start putting your questions on the platform now. There's a little thing I hope you can see that says chat and one that says questions. Please use the one that says questions if you can. We will see the chat too, though. So you can start putting in questions. Two of the presenters here, Amy and George, had plenary speeches, so you might already have questions for them. You can go ahead and start. And then as the other speakers give their presentations, you can start putting in questions. This workshop will be recorded, is being recorded. And the way this platform works is that the first few people who join are on the recording. So if you don't want to be on the recording for posterity, then just turn off your video. And as I said before, everybody should be muted so we don't have problems with that. If you have technical problems, you can put something in the chat, or you can go to the Help Center, which should be on the bottom right of your screen. So those are kind of the housekeeping items. And then I'm going to tell you a little bit about myself and the other panelists. So as I said, my name's Paula Dinerstein. I'm the general counsel for Public Employees for Environmental Responsibility, or PEER for short, we call it. And we're an environmental whistleblower group. And one of our big focuses is scientific integrity, which to us means the ability of government scientists to work without political interference and to communicate freely. And that's what I'll be talking about today. I'd like to introduce the other members of the panel. We have George Kimbrell, who hopefully some of you heard speak earlier. He's the legal director of the Center for Food Safety, which is a nationwide nonprofit whose mission is to empower people, support farmers, and protect the earth from the harmful effects of industrial agriculture. His legal, legislative, and policy work runs the gamut of many of the things that CFS works on, including pesticides, pollinators, organic standards, genetically modified plants and animals, factory farm pollution, food labeling, foodborne illness, and aquaculture. And among other landmark cases he's been involved in, George was the counsel in the first U.S. case that went to the Supreme Court on the regulation of genetically modified crops. He received his law degree from Lewis and Clark Law School, and since 2010, he's also taught there as an adjunct professor. And he'll speak today about recent and pending litigation involving pesticides and how that's going to affect future policy. So, and next we have Leslie Touart, and I hope I'm pronouncing your name correctly. He is a PhD scientist and currently Beyond Pesticides Senior Science and Policy Analyst. And he's also has his own consulting firm, Equiparent Consulting, where he provides services to assist with ecotoxicity, test data review, risk assessment, and regulatory compliance. He's a retired senior biologist from the US EPA, had a long career at EPA. He served in the Office of Research and Development, performing marine organism toxicity tests. And then, he went on to the Office of Pesticide Programs, performing ecological risk assessments and developing test guidelines from the small molecular-based in vitro assays to large community-based ecosystem level aquatic macrocosms. And he spent the last 18 years mainly working on the endocrine disruptor program, screening program, and he oversaw all the validation efforts for testing the ecological test methods in the program. He's very active internationally with the Organization of Economic Cooperation and Development in test guidelines, validation, and harmonization. And his efforts continue in advancing probabilistic ecological risk assessments, endocrine toxicology, and international outreach. And he earned his doctorate in environmental biology and public policy from George Mason University. And he'll be speaking today about a specific example of where the EPA implementation of the pesticide program actually violates the pesticide law and how that should be confronted. And last but not least, we have Amy Lewis, who also spoke earlier today, and hopefully some of you heard her. She's the Chief Policy and Communications Officer for the group Wild Foundation. She helps solve collective action problems for the conservation and environmental movements, and she has over 20 years of research and practitioner experience in social movement building. As part of her role at the Wild Foundation, she serves the Nature Needs Half network, which you heard about in her talk earlier today. And it's an international team of scientists, policy experts, philanthropists, and communication professionals who are spearheading the historic effort to protect half of the Earth's land and seas in time to address the existential emergencies of climate breakdown and mass extinction. And Amy will be speaking on movement building and specifically in relation to this global movement to save 50% of the Earth's land and seas. So I'm going to go on now and give my presentation, which I hope I can do with the share screen function. Let's see here. Sorry, have a patience for this. Okay, and what I want to do is pull up this PowerPoint. So okay, so oh, Neil.
I think we've lost Paula. I'm not sure what happened. But I'm wondering if one of the rest of you would like to start with your presentations while Paula rejoins us. George, maybe? You want to go ahead?
Yeah, I'm happy to do that if that's how we want to go. I'll try not to make the same mistake
You sound a little muffled. If you could maybe move closer to your microphone, I think that would help.
Okay. How about now?
That's better.
That's better? Okay. Sorry about that. Yeah, I don't know. New technology for all of us, I think, this swap card. So apologies on Paula's behalf. I guess I will dare to try to show slides. Let's see what happens here. Did that work? Can people see that?
Yeah, I can see it.
All right. How about now? Can people still see it? No, yes?
Yes.
Okay, I'll just leave it maybe just like this to be easier. I can see you all. All right, so so I'm George Kimbrell. I've got 10 minutes here. I'll put myself on a clock. I think if hopefully folks, some of you at least watched my presentation that I taped for the plenary this morning. So I'll try not to repeat what I did there, but basically, want to try to have some take homes from what's going on in the courts. As everybody knows, Environmental Protection Agency's overview of pesticides can best be described as captured by industry. There are major political problems there, and some of it is with their authority, and other aspects of it are just with the political will to do a better job regulating pesticides. And that spans all the different administrations with regards to Democratic appointed people or Republicans, although the last 4 years was definitely a nadir as far as it goes. That leaves the courts as one of our last avenues for democratic involvement. And so our organization and a number of others, have gone to court to try to overturn EPA decisions. And I spoke about some of them this morning. I just want to highlight a couple of more recent ones where we've tried to breathe life into EPA oversight when it comes to pesticides, and some of the fallout from that more recently at the agency itself. So the first one is the dicamba litigation that we won last year in front of the Ninth Circuit. Let's see if I can turn my volume up. I see in the chat that some people can't hear me. I apologize for that. I can also put some earphones in potentially. And the dicamba case was a pretty big deal. I spoke about it this morning, but bottom line is that it had a number of precedential holdings that EPA will now have to implement in its other pesticide approvals that should improve things as far as the type of costs that they have to assess when it comes to things like pesticide drift and harm to the environment and harm to farmers from it. Let me put these earphones in and see if it helps. Okay, can folks hear me better now or not? Caroline, is that any better? Or Amy? Okay, great. So, I think there's not a lot of good pesticide decisions in the courts because FIFRA has been interpreted the last 40 years by the courts in a very weak sauce type of a way. And so really trying to get some good holdings in it has been a real challenge for our community writ large. And so the dicamba case really stands out because it's a good case with a lot of good holdings that EPA will now have to grapple with. And what we've seen in the Biden administration this spring is that they are, in fact, having to take a look at other assessments when it comes to pesticides like glyphosate or atrazine and sulfoxaflor, and really try to bring their decisions for those other pesticides in line with the new holdings of the Ninth Circuit from the dicamba litigation. The dicamba litigation is, there's a saying in the law that says, good facts make good law, and it certainly is that case. It was a dramatic increase in over-the-top spraying of dicamba into the environment, through the corn and the soy and cotton that's genetically engineered to be resistant to it for the first time. And so it dramatically increased dicamba use in agriculture. And of course, dicamba is a very volatile, drift-prone pesticide historically, and these new versions were no exception. So, it was very controversial approval at EPA, and certainly a lot of the predicted outfall into the environment and onto other farmers' crops from vapor drift came true, unfortunately. But it was an aspect where we could really shine a light on the not singular, but rather systemic problems at EPA as far as the way that they review pesticides and their inability to really, and this slide just shows all the different acres that were harmed that first summer of 2017 after dicamba was approved. Here are some of the holdings from the case. I mean, essentially, the Ninth Circuit said that EPA needed to do a better job considering, analyzing, and weighing the costs of pesticide approvals, because to this point they had pretty much given that short shrift when it came to environmental, social, and economic costs. So particularly on the crop damage side, the dicamba case had precedential holdings that said EPA really has to look at the evidence in front of it and try to quantify and analyze what the harm from drift will be to other farmers. Because of course, all kinds of vegetable trees, not just soy, but all kinds of crops are harmed by dicamba, which is a potent pesticide, as I mentioned. So when it came to quantifying the amount that was harmed in the environment, EPA had a duty to do that. They also had a duty to look at things like defensive adoption and the monopolistic costs to agriculture at large from having crop systems that are patented and genetically engineered to be resistant to one or more herbicides, like the dominant Roundup Ready system has been for the last 25 years. And then now we have with the dicamba resistant systems, or Enlist Duo, which is Corteva, formerly Dow's, 2,4-D and glyphosate resistant systems, among others. What is the cost of farmers economically and socioeconomically of being forced to lose the ability to plant the crop of their choice and instead, buy these herbicide-resistant seeds defensively, even if they don't plan to spray and don't support spraying in that manner. And then finally, I think most importantly was the improper label holding from the case. And really, that means that, label is a real misnomer when it comes to pesticide oversight. Here, we're talking about these 40-page websites with these complex Byzantine instructions for farmers. And EPA basically has predicated for years its approval of these pesticides on the ability of this mitigation in the real world, but really has never tested whether it can be followed in the real world. If they say, don't spray if it's between 3 and 10 miles an hour wind blowing. And of course, in West Texas, if you're a farmer, the wind is always blowing, above 10 miles an hour during the growing season. And so it's really EPA pretending to say something is safe, but not really testing if it's possible, even in a good faith effort by users to do it in real world conditions. What is the practical efficacy of those measures? It's like saying this pesticide is safe if you only spray it if there are unicorns in your field, but of course there are never unicorns in your field. And so instead, the Ninth Circuit in the dicamba case said, no, when you predicate safety findings on a label measure, you need to really analyze it and do your homework as to whether it works and whether farmers can actually follow it in the real world farming conditions of wherever they are, whether that be Texas or Iowa or Arkansas. So a really important case there. I would just highlight a few more in my last few minutes. I mentioned the glyphosate case. That's a big one where we're raising claims right now in front of the court on behalf of farm workers and farmers on the health side. It goes hand in hand with the class action litigation having to do with cancer harm that the Ninth Circuit recently reaffirmed in the Hardeman case. That's an important case for regulatory review because it said that those state-based cases are not preempted under FIFRA. So, obviously, the problem with class action litigation, it's only after the fact. So it's, you can never bring somebody's health back. So it's a financial impact to the pesticide company. But what we really need to do is address these harms when it comes to health or the environment at the outset, before they're approved. And so that's what a lot of the registration review cases are trying to do, is make sure that that happens and we don't have this massive class action litigation after the fact. So the glyphosate case is really important. And right now, like I said, EPA is taking a second look at parts of it based on the dicamba decision, but continuing to defend notably the cancer assessment that we also challenge for inhalation and dermal exposure. The atrazine case, obviously after glyphosate's second most widely used pesticide in the United States, will be a big one to watch later this year. The Trump administration on its way out the door reapproved dicamba despite the big win in the summer of 2020. So we're back in court litigating that. The questions are basically, Did they fix it after 5 months later when they approved it 3 days before the presidential election with a big press conference in the Georgia cotton field and a bunch of lobbyists from the farming organizations? Our argument is no, they didn't fix it. So we'll see. That's another big one to follow. A lot of the issues are the same. Sulfoxaflor is a neonicotinoid, or debatable. Some people say it's not, but it acts in the same systemic way. So there's harm to bees, harm to endangered species from it. That's another case we're litigating right now that was won a few years ago in the Ninth Circuit, 2015 and 16. So this is the second approval of it. We're litigating it. Again, EPA has admitted legal error, but asked that the product stay on the market, which is, a disappointing position for the Biden administration to take, but nonetheless, that's the one they're taking. So that's a big one to follow as well. And the chlorpyrifos case is not our case, but it's a very important case on pesticide tolerances. So I would also highlight that as a really, really important case in FIFRA law that came down earlier this year as far as what EPA has to do when it sets tolerances and when it has to finally address petitions that ask for tolerant modifications or revocations. And that'll lead us into Paula's presentation, I think, pretty well. I think she's going to talk about scientific integrity. I would just say what we have seen that's been good from the Biden folks is some movement there. And as related to my cases in particular, there was a memo in March and then an Inspector General report just last month that came out, both of which had highlighted the dicamba decision by the Trump administration as one where politics trumps science and the law, and where internal science staff were overruled at various really critical junctures. Of course, that's not surprising to us, having seen the administrative record and litigated the case. And it's nice that EPA is coming out and calling itself on the carpet with regards to that. However, at the same time, they're not taking back the more recent approval of dicamba, which in our view was made by the same Trump EPA, as I said, right before the election, and is similarly politicized and unlawful and not sound scientifically. So only goes so far. They're willing to say we messed up when the court takes them to task, but not before that, in my experience. So anyway, overall, that's it. That I'll stop there and happy to take any questions.
Okay, so thank you. I apologize for my technical difficulties, and thank you, George, for stepping in and doing your presentation. Really appreciate that. And I will now try to get my PowerPoint going, and the questions will come at the end. So yeah, save your questions for George, put them in the question area or the chat. And I will go to my presentation. Oh, you have to go to window and then do the PowerPoint. All right. Ask if they can see it. So hopefully everybody can see. Can somebody who doesn't have their mic off respond that they can see this PowerPoint?
Yeah, I can see it.
Okay, great. All right. So I'm going to talk about scientific integrity in the federal government. And scientific integrity, it's a cross-cutting issue because it's the backbone of much of environmental policy making, including on pesticides. And too often, scientific conclusions from the agency scientists are altered or suppressed to serve the needs of industry. And this occurs in all administrations, Republican or Democrat. But it got worse under George Bush and Trump. Now, the advantage of if you get a really strong scientific integrity policies in place and vigorously enforced, they can really help make better scientific decisions. It's the wrong PowerPoint. And if you, sorry for just a minute.
You can't change it, just keep going.
Okay. to go back. But I pressed stop sharing, so. We can't get the right one.
Where is the right one? This is the only PowerPoint you have up. You have to go with the one you have.
All right, so my technical difficulties seem to be continuing, but I will. So the question is, how did we get to where we are today? And the history of the scientific integrity policies in the federal government is that there actually were none before Obama, formal scientific integrity policies. And the Bush administration was notorious for altering scientific findings. The most prominent example was a woman named Julie McDonald, who was a non-scientist, but who was hired high up into the Interior Department of the Bush administration, and who would do things like in an endangered species review that found that a particular activity would endanger the continued existence, jeopardizing continued existence of a particular species, she would just insert the word not. It would not. The Inspector General did an investigation and found that she had engaged in misconduct. She was more or less forced to resign. And after she left, the the Fish and Wildlife Service had to repeat several of the ESA reviews that she had meddled with. So when Obama came in, he came out and said that he was going to fix all of this. And as I said, for the first time in history, he directed federal agencies to issue scientific integrity policies for their agencies. And they were supposed to contain these major components that political officials could not suppress or alter scientific findings, that scientific information developed by the federal government would be made public, that there would be transparency in the development of scientific information and its use in policymaking, and that the selection of scientists for hiring would be based on scientific credentials and integrity. So that all sounds good, but in reality, the policies were weak and unenforceable. And this is for several reasons. The policies, one, they didn't protect scientists to be able to publish and lecture. Some agencies like the USDA actually forbids the publication of anything that can be construed to impact policy, which is kind of amazing, but that's what a scientist, who puts out a peer-reviewed article in a peer-reviewed journal, if the USDA decides that somehow this has an impact on policy, like it's saying that GMO crops cause harm or certain pesticides cause harm or something like that, they can be taken to task for putting something like that out, particularly without the permission of their management. And the policies in general, not only USDA, don't have any clear direction that scientists can publish and communicate and share their findings without the need for management approval. There's a lack of transparency. In a lot of cases, somebody will file a scientific integrity complaint, it will be investigated, and then the management will decide that that is not going to be made public. The results of the investigation are kept secret. They're also not done by neutral parties a lot of the time. A lot of time it's management investigating itself, or even if they do have some kind of neutral board to do the investigation, the management has the last word as to whether it'll be made public or what will be done. Additional weaknesses are the lack of enforcement. Management can just ignore complaints. There's no particular way that you can file anything if your complaint is summarily dismissed to oppose that. A lot of complaints we have seen have just simply gotten lost and never responded to. equally important, there's no consequences for the people who violate scientific integrity. And the Interior Department, in fact, forbids the panels from recommending any kind of discipline of managers. And so the basic problem with these policies is that they have the agency investigating itself, and they don't require that they take any action. So some examples that peer has been involved in where, or at least knows about, where these scientific integrity policies have failed is one, there was a scientific integrity complaint that senior Fish and Wildlife Service official told the scientific recovery team on the endangered Mexican wolf to alter its findings, and the complaint was simply dismissed. There was a decision by the National Oceanic and Atmospheric Administration to block an investigation where the official predictions of the flow rate of the Deepwater Horizon spill were less than half of the reality. And so somebody was cooking the books, and the agency just decided to sweep it under the rug and not investigate it. We were involved in the filing of a scientific integrity complaint that included 44 former and current federal employees about senior officials excluding scientific information and ignoring their own scientists with regard to the rewrite of the Waters of the United States rule that the Trump administration did. And we even had a client who was a scientific integrity officer himself and was fired for complaining about the failures of his own scientific integrity office and program in his agency. So what would be a really good scientific integrity policy? What should we be trying for? So there should be no barriers and no reprisal for government scientists sharing results inside or outside of government. There should be protections for filing differing scientific opinions, and those should be made public. Some of the agencies do have processes for filing differing scientific opinions, but then they're considered confidential. They should be made public, and if a case goes to court, like if one of the cases George has, the administrative record should include these differing scientific opinions so that an agency can't quash the fact before the court that some of their own scientists didn't agree with what they did. All the reports of scientific integrity investigation should be made public. And also another big issue that we have found with a lot of clients who come to us is that they're not really technically whistleblowers. They're not saying my agency has broken the law or has engaged in some wrongdoing. They're simply doing science that comes out with results that some industry partners, players don't like. And we had that situation with John Lundgren, who is, I believe, speaking at this forum, where he was just doing research that showed that some of the problems with industrial agriculture and how a more biodiverse farm was actually more productive, the harms from GMOs, from pesticides. He was just doing science and was retaliated against for that. So we need a change in the law that will actually protect people who are just doing science and don't meet technical whistleblower requirements. And perhaps most important, the policies need to be enforced. All scientific integrity complaints that have probable cause should be investigated. The investigation should all be made public. The policy should include penalties for scientific misconduct and requirements that they be pursued. And political appointees who manipulate science should be reported to the president, and that should be made public also. So what did the Trump administration do about scientific integrity? As we just went through, the Obama policies weren't that great. However, Trump almost completely ignored them, and he brought the disregard and disrespect for science to a new level, as that probably everybody here is well aware. And one example of that, which George just mentioned, is the dicamba case, where the Inspector General and the court in the Ninth Circuit, in the case that they won, found that EPA's decision that the senior managers interfered and changed the conclusions of staff scientists. And as a result of that, the Ninth Circuit found that the EPA substantially underestimated some of the risks and completely ignored some of the others. So, and that's some of the ways that sometimes scientific misconduct gets brought to light, is when you bring it in a court case. And a court will look at the validity of what was done scientifically. So the Biden administration has also come in with some really good language and rhetoric about how they're going to fix these problems. They're going to revitalize scientific integrity policy. They've created a task force on scientific integrity that has already had one meeting, and whose goal is to, uncover the problems in the past and examine them, and then improve scientific integrity policies for the future. It looks good, it sounds good, but we're already seeing a couple concerns that we have with it. One is that we have heard through people working at EPA that the new head of the office that oversees pesticide regulation, as well as the scientific integrity officer for EPA, have made statements that, well, what we're going to do, we're only going to look forward. We're not going to look back. We're not going to punish anybody for anything that happened in the past. It's going to be happy and peace in the valley. However, that it will not be possible to change the culture going forward in the future if you have those same people, who year after year committed scientific integrity violations, and a lot of them are the same people who are at the revolving door with industry. If they are allowed to stay in place and suffer no consequences for what they have done, the future is not going to be any different either. We also have learned that the task force itself contains as members some of these very same people who have failed to implement the scientific integrity policies over the past years. So we're going to be dogging this very closely, PEER as well as a lot of other organizations. We'll be filing a lot of comments and participating and working hard to push Biden's administration to meet his rhetoric and create some truly effective scientific integrity policies. So that is all I have right now. Thank you. And we can go on to the next presentation.
Okay, Paula, this is Les. I think would be next up. So I'm going to, hopefully I can do the share and it'll come through.
Yeah, let me see if I can get rid of my share so that you can do yours. Okay.
Okay. Okay, can you see my presentation?
Yes.
Okay, let me, I can make it a little bit larger. So what I was going to talk about is an issue within FIFRA and the agency in terms of how the agency utilizes or administers the act. And this is an unclassified pesticide issue. And FIFRA, the Pesticide Act, requires that all pesticides be classified as either restricted use or general use. And I'll describe these a little bit later. But yet for decades, many registered pesticides go unclassified. And this is a result of a disconnect between the statute and the regulations that EPA uses in promulgating or administering the law. And just briefly go back, pesticide registration is a fairly complex process. It's scientific, legal, administrative procedure that EPA examines what's been submitted to them. The proponents for registration have to identify what their the particular aspects of their pesticide use site, amount, frequency, how it's going to be stored and disposed, and such. And then in evaluating the risk to this, the agency looks at harm to humans, wildlife, fish, plants, endangered species, basically all non-target organisms, and also concerned with contamination, surface water, groundwater, leaching, spray drift, and also to an extent volatilization that can, these are things they're supposed to look at. And the assessment is based on the product label, and this is key. The label is the law. Once EPA is granted a registration, EPA notifies the registrant as to what it is, but the law becomes, or the label becomes a legal document at that point. It's the law. EPA approves the label during the registration evaluation, and generally it may not be altered or changed. And if there's any changes, those have to go through an additional review. And so all the information that's in there, the user is legally responsible for following that to an extent. And FIFRA, as you all know, is a risk-benefit statute, and that's the crux, risk-benefit. Risk are balanced against benefits, and benefits are kind of a subjective viewpoint in terms of how these are evaluated. Costs are assumed into the risk considerations, but the benefits can, for the a risk manager or the decision maker, they can interpret to what extent they believe the risks have been outweighed by those benefits. So going back to get specific on the restricted use versus general use, the restricted use is pesticide that may cause unreasonable adverse effects without restrictions and precautions involved. And these include injury to the applicator or to the environment. And these can only be obtained and applied by or under the direct supervision of a certified applicator. Certified applicator will have been trained in terms of how to read and interpret the use, and familiar with the various provisions in terms of how pesticides can be used and the dangers they can pose. A general use pesticide, on the other hand, is one that EPA has determined will not generally cause unreasonable adverse effects. And again, that reasonable, unreasonable, that's somewhat of a subjective judgment. It's presumed that an untrained user will understand and adhere to the product labeling and not apply it inconsistent. So a general use is available to the general public, and anybody can go down to their local hardware store or garden store and buy these products, the general use ones. But contradiction that I mentioned between the Act and the regulations, FIFRA in section 3D1 says, as part of the registration of a pesticide, the administrator shall classify it as being for general use or for restricted use. And it goes on to explain that when a pesticide does not pose an unreasonable adverse effect, the administrator will classify it for pesticide or its particular uses for general use. And conversely or respectively, if it's determined that it may cause an unreasonable adverse effect without restrictions, the administrator shall classify that pesticide for restricted use. And in contradiction to this, the regulations that the agencies promulgated and utilized in administering the Act in the 40 CFR 152, 160 state a pesticide may be unclassified or it may be classified for restricted or for general use. The agency does not normally classify products for general use. Products that are not restricted remain unclassified. And so the question then becomes, does that matter? For all intents and purposes, unclassified pesticide is treated as a general use pesticide that is available for sale to the general public. But I would argue that yes, that is a concern. It does matter because that unclassified pesticide, there really isn't the agency asserting that it's safe for general use. In an unclassified situation, it may not, or at least it hasn't been affirmed that it's gone through those extra considerations in terms of how it might be misused by an untrained user. So a pesticide is presumed to be, under FIFRA, it's presumed to be hazardous, and a proponent has to demonstrate with credible evidence that will not cause unreasonable adverse effects. And that's really the strength of FIFRA in that the proponent or the registrant has to demonstrate that it can be used safely. So what can be done about this? There should be no option. You shouldn't do the extra step. If they're interpreting unclassified as general use, then they should state that there should be a banner, because on the label for restricted use, there's a banner that says it's restricted use, can only be used by or under supervision of a certified applicator. There's also a banner that talks about general use, which means it can be used by anybody, and that needs to be in place opposed to unclassified. And they should improve the classification review process to include those additional considerations so that a general user that may fail to understand or abide by the product label directions, they need to interpret how that might cause problems. An example would be employing estimated exposure concentrations in the risk assessment based upon application rates higher than permitted label rates to simulate a typical user's possible misuse or just misunderstanding. Again, when the agency does a risk assessment, that risk assessment is based on the specifics within the label. So if the label says use 1 pound per acre, they do the assessment based on 1 pound. If it's 1.2 pounds, they don't consider that. The agency only looks at the 1 pound. So if there's an overage, that could be a problem. And so anything that becomes, when they look at the restricted use criteria, anything that's supposed to come close to that limit would be of concern, and so should bear the use classification. And just to finish up, I just want to talk about the pesticide risk assessment and the emphasis. And I put emerging in parentheses because these endangered species, endocrine disruption potential, honeybee pollinator risk, and reduced animal testing. These have all been emerging emphasis within the agency for the past couple decades, really about 25 years. So they're not really that much emerging or recent. They are ones that have been around for a while. So with that, I'll come back.
Okay, so I believe we're ready for Amy's presentation.
Hi, can you hear me okay?
Yep.
Okay, great, thank you. Yeah, I just want to say hi to everybody in the audience and to thank my fellow panelists. It's really an awesome honor to be here presenting with you, and I'm learning so much from your presentation, so thank you. I guess I kind of want to take a slightly different approach than what has been previously presented on the panel, because what you're looking at in the other distinguished panelists is decades worth of institutional knowledge and expert knowledge, and the individuals that have presented so far are holding the line inside some of the most important institutions, the courts, regulatory bodies, holding the line on some pretty important and pretty technical issues. And I want to ask the question, how can we bring reinforcements to the individuals that are doing this day in and day out for their entire lives, their entire careers? How can we bring reinforcements to expand their power and their voices and to make what they're attempting to do more efficacious and start gaining more ground? And so that's the first question I'm going to ask. And I just kind of want to leave that as an overarching question for this presentation and as a way to connect my work to what others are doing on this panel. The other thing I want to look at is, I think, a question that each and every one of us have probably asked, maybe at least once, but probably multiple times in our journey around pesticides and environmental challenges. And that is, why isn't society doing more, right? Because everybody here in this audience, on this panel, we're all really informed. And because we're informed and we know what the dangers are around this issue, we're trying to take action because we're rational, right? That's how this works. And so the question is, why aren't other people joining us in doing this? And I think there's two answers to that question. One is how we as individuals would answer that question. And I bet you all have answers and I would love to hear what they are. But we as individuals would answer that question if we were asked, why aren't we as a society doing more? And the other answer is implicit in our strategies that we use and some assumptions that we make. So I want to look at what the answer to that question is first, according to our strategies. And if you look at what everybody's doing on this panel, and also probably just kind of what we default to around environmental issues, is that why aren't we doing more? According to our strategies, we're not doing more because we're ignorant, right? Our strategies tend to revolve around gathering more evidence and more evidence and more evidence. And we have these file cabinets full of evidence, and we give these information dumps to people with all of this evidence about what's wrong with the current system and why it's dangerous and what we should be, why we should be changing to something different, right? So one answer to that question is that we are ignorant as a society, and we're not doing more because we don't know that we should be doing more. But the other answer to that question is probably, it's definitely the answer I would give. It's probably the answer that many people in this audience would give, is that we lack the political will to do it, and we lack coordination. So it's not ignorance. We assume that society has, or our leaders have a relatively good idea about what's going on. But what we're lacking is the will and the coordination to do what's necessary to create a safe society. And that begs the question, if this isn't a question of ignorance, if it's a question of will, that begs the question of, are we really rational? Are we as a species rational? Can we trust ourselves to make good decisions in our own self-interest based on our rationality? And the Enlightenment 300 years ago would tell us that, yes, we are rational, that we act on our own best self-interest, and that overall, that as we do this, acting kind of selfishly and rationally, that society will improve. Well, we're kind of at this turning point where we're noticing, when it comes to climate change, extinction, pesticides, that actually self-interest and individual self-interest, at least, isn't necessary, or something isn't adding up to leading to creating this collective change that we all seek. Why is that? Now, I'm going to introduce a couple of names here that maybe some of you will freak out a little bit about, but I'm introducing it anyway. And I mean, it's going to be a little bit fun, right? It's a thrill to talk about Marx and Lenin in this day and age. But if we go back to Marx, and a lot of people, associate Marx obviously with the Communist Manifesto and whatnot, but he actually didn't spend most of his career writing about communism. That was only a fraction of his writing. What he wrote most about was change and kind of these phases of development that the society goes through and why those phases come about. And Marx believed that we were headed into a new phase because of the collective grievances that had been caused by untrammeled capitalism in the industrial towns and the suffering that was occurring there. And he believed that collective grievances, a lot of people located together in urban areas working in miserable factory conditions, would lead to a revolution in a more just society. Marx was wrong. Most people think he was wrong because communism didn't work out the way he thought it would. But what he was wrong about is that actually collective grievances aren't enough to create change. You actually need some type of organizing force and some motivational force there. Otherwise, people kind of just continue to suffer. Yes.
So, Amy, I'm really sorry, but because of our technical difficulties, we're running out of time. So we have this hard stop. I'd like to make it go longer, but the platform is going to stop us. So,
okay.
So I'm really sorry, and we'll ask you to just kind of wrap up with your conclusion. And then for people who had questions, everybody here, we have contact information on the site. You could ask us questions afterwards and we'll be happy to answer.
Okay, thank you. So essentially, what we're looking at is it's not rationality and knowledge that drive collective action. It's actually a sense of urgency and identity. And there's two senses of urgency we need to be looking at cultivating. The first is the individual sense of urgency, kind of that grassroots sense of urgency that pulls people in. But the second sense of urgency is the leadership sense of urgency, creating conditions with the grassroots mobilization that puts us on the offensive, that creates conditions where leaders feel urgency to change. And that comes at the bottom line. Targeting the bottom line for those individuals in votes and in profits is what will lead to that type of change. And I'm happy to speak with